The Supreme Court has been hard at work finishing up the term. You know, gutting the regulatory ability of federal agencies, marginalizing the homeless even more, and of course, legalizing bribery of state officials. And yet, the decision we've all been waiting for, the biggest decision of the term, the question of Trump's immunity, has been put off until at least July 1st. But today's Supreme Court decision may just change everything. Today's decision, Fisher versus U.S., may actually render immunity as moot. And if it does, I just want to point out that it would be a moot decision, not a moot court. Today's decision involved a former Pennsylvania police officer who participated in the January 6th insurrection. And despite the spin that the right-wing media try and put on the insurrection, no, this former police officer was not escorted into the building by DC Metro Police. This guy disgraced himself and the badge by assaulting the police officers who attempted to protect the Capitol building that day. And so let's make no mistake about it. This guy is guilty of assaulting officers and interfering with the police during a civil disobedience. He is, in every sense of the word, a violent criminal. And today's ruling does not change that. He will still go to jail for what he did on January 6th. So today's ruling will have no impact on his conviction and little impact on his sentencing. In fact, hopefully it will inspire the district judge to throw the maximum sentence at him for his violent crimes. If it doesn't impact Fisher that much, then why is today's ruling such a big deal? Because it impacts Trump and the federal charges against Trump. At issue in the Fisher case is the federal government charging Fisher, Trump, and hundreds of other insurrectionists with obstructing an official proceeding. And this makes it the wackiest case and one of the worst decisions since Plessy versus Ferguson. Because obstructing an official proceeding is exactly what the J6 insurrectionists planned for and accomplished. Was the official proceeding obstructed? Well, let's ask legal expert and eyewitness Josh Hawley. Yep, looks to me like senators running for their lives pretty much showed that the proceeding was obstructed by the presence of violent insurrectionists and kooks. But today's Supreme Court decision said no, it was not obstructing. How the heck do they come up with that? This is where the wheels just fall off the cart. In a 6-3 opinion that includes football face mask rules and what can only be described as the invasion of the body snatchers gone wrong, the Supreme Court ruled that obstructing means this and not that, and let Fisher off the hook, as well as all the others charged with obstructing, including Donald Trump. Now, you would expect a 6-3 decision that shields Donald Trump from prosecution to line up on traditional conservative versus liberal lines, but not so. Liberal justice icon Ketanji Brown Jackson sided with the majority, and Justice Amy Coney Barrett wrote the dissenting opinion, joined by Justices Sotomayor and Kagan. The heart of the case for the majority is not that Fisher and the others obstructed an official proceeding. They did. But the majority asked, what does obstructing mean? Enter the clown show. Here is where it gets into the weeds and likewise gets absurd. The law at issue here is Sarbanes-Oxley, passed in 2002. And 18 U.S.C. Section 1512, subsection C, paragraph 1, states that this law applies to anyone who alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding. Okay, so no messing with documents. Although there's a lesson Trump didn't quite learn. But all right, it's illegal to mess with documents that are going to be used in an official proceeding. But then the law goes on. The law also includes Section 1512, subsection C, paragraph 2. And now, believe it or not, paragraph 2 follows paragraph 1. It's a sequential kind of thing. I'm sure you get it. Paragraph 2 states, and here I am quoting from the decision itself, the next subsection extends that prohibition to anyone who otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. Now, is it just me, or does paragraph 2 say otherwise obstructs? But the majority opinion actually argues this, that paragraph 1 defines the scope of activities, that it is, in essence, a defining list. The majority argues that if the behavior of the accused does not fit what is described in paragraph 1, having to do with documents, then it is not covered by the law. They write, the otherwise provision of Section 1512, subsection C, paragraph 2, is similarly limited by the preceding list of criminal violations. In a stunning analogy, Roberts writes, a zoo might post a sign that reads, do not pet, feed, yell, or throw objects at the animals or otherwise disturb them. If a visitor eats lunch in front of a hungry gorilla or talks to a friend near its enclosure, has he obeyed the regulation? Surely yes, although the smell of human food or the sound of voices might well disturb gorillas. The specific examples of impermissible conduct all involve direct interaction and harassment of the zoo animals. But the analogies get even worse. Roberts writes, for instance, a football league might adopt a rule that players must not grab, twist, or pull a face mask, helmet, or other equipment with the intent to injure a player, or otherwise attack, assault, or harm any player. If a linebacker shouts insults at the quarterback and hurts his feelings, has the linebacker nonetheless followed the rules? Of course he has. The examples of prohibited actions all concern dangerous physical conduct that might inflict bodily harm. Trash talk is simply not that kind. And Justice Jackson concurs with this decision and this analogy. So, okay, Harvard and the University of Michigan, why are you not teaching in your freshman speech class that reasoning by analogy is the weakest form of reasoning? All the other universities teach that. And Justice Jackson, you went to Harvard. What do you know about trash talk anyway? Because here's a typical example of Harvard trash talk.
Heavens, a Yale man!
And look, I admire Justice Jackson's independent thinking and not being locked ideologically into one mode of thinking. But where is the common sense reading from even a couple of days ago when she admonished the court for legalizing political gratuity? That rule was taken over by Justice Barrett, who wrote, the court abandoning that approach does textual backflips to find some way, any way, to narrow the reach of subsection C, paragraph 2. I respectfully dissent. But the heart of the matter for Barrett is indeed that subsection C, paragraph 2, prohibits obstructing, influencing, or impeding an official proceeding by means different from those specified in subsection C, paragraph 1. So now it is Justice Barrett who is taking the majority out to the woodshed for twisting a decision between all recognition and logic, and rightfully so. So the majority decision is baffling, but it is nothing but good news for Donald Trump. Because unlike Fisher, Trump is not guilty of assaulting a police officer. And yes, that horrible comb-over is a visual assault on all of us. But that's not in the indictment either. With the obstructing an official procedure charge, the government has an easy case against Trump. Trump called the mob in, he fired them up, and then he directed them at the Capitol with a specific purpose to stop that certification. Without being able to charge Trump with obstructing an official procedure, the government has a much harder case to prove. That's why this case is just as important as immunity. And today's crazy switcheroo between Justices Jackson and Barrett should give pause to anyone about being able to predict this court. Aside from Thomas always ruling for Trump and for corporations, that is. But if there is a ray of light in any of this, it's that Justice Barrett's opinion may just indicate that she is not willing to go along with full immunity for Trump. We'll know soon enough. I'm Anthony Vincent Gallo for Occupy Democrats.